All right, as promised, an update on the lawsuit filed by Andrew Robison, the former quarterback of Vanderbilt Catholic High School, who filed a suit against Vanderbilt Catholic, Coach Jeremy Atwell, Hornville High School. And, of course, the young Andrew Robison was cleared to play at Hornville on Friday of last week. However, the school, out of an abundance of caution because there's an LHSAA hearing this week, decided it might be best to hold him out of that game. So it's very complicated. And when we get complicated in the legal realm, we bring in Fred Fondren, who joined us last week. Fred, good to see you again.
Pleasure to be here.
All right, so we know they held him out at Friday's football game. Just to give folks an update, there's a hearing in St. Charles Parish on Wednesday. What's that hearing all about?
The hearing Wednesday only pertains to the TRO issued against LHSAA. And the TRO, as you recall from last week, is only issued with the allegations from one side because they allege irreparable harm if the TRO is not granted. So now there's a hearing on Wednesday where LHSAA will be able to come in, defend its position, defend its investigation, and the court at that point will hear from both sides and determine whether the court order should continue or not.
All right, so we've been busting up the LHSAA pretty good about just their practices in general. A lot of that needs a magnifying glass on it. A lot of it needs to be changed and fixed because really the victims in all of this are 18-year-olds on down, in my opinion. Vanderbilt Catholic's football team, although they won a great homecoming game, which was great for them, and Hornville's team, the kids are all dealing with this. The young Robinson kids dealing with this. He's missing a senior year. But there's discrepancies where the adults come in. Let's bring up the form that the LHSAA used where there was some talk of where the father was going to work. Here on the residence eligibility form, Miss Robinson put, "Father is coaching at Hornville." That's in quotes, where it asked for parents' current employer. That was dated July 30th and also signed by the athletic director at Hornville, which confuses me even more. Mr. Robinson said that he interviewed for a basketball opening at Hornville High. However, the athletic director said that was not true. They didn't have a basketball coaching vacancy, and they have never interviewed Mr. Robinson. Miss Robinson said she was sorry for the mistake. It was wishful thinking on her part. First of all, I'm confused. Talks about the athletic director signing the form. Then the athletic director says, I didn't sign the form. Can you clarify that for me? What happened?
Well, I don't think he denied signing the form, but clearly he must not have reviewed it very carefully because what he told the investigators is in direct conflict with what he approved on the form. Remember, the statement by Ms. Robinson was in writing. Right. So when he signed off on that form, presumably he's endorsing what she's saying or at least verifying its truthfulness.
Yeah, but in fairness, Miss Robinson got that information somewhere and may have proceeded with her talking at the testimony, but it turned out to be not the right thing.
It did. I don't want to speculate as to where she got her information, but I would point out that even though she said that might have been wishful thinking on her part, apparently Mr. Robison also stated to the investigators that he was interviewing for a job at Hornville. So it's not only her written statement, but his oral statement to the investigators that appears to be inconsistent with what the athletic director ultimately said.
All right. So now we move to the fact that the LHSAA slapped a 1-year suspension on the young quarterback. 1 year. You have to, they break it down. It's either, I think you can get a 1 year for recruiting violations, or if you don't have a bona fide move, which includes academics, not just for athletics. Can't move just for athletics. So their big contention was we followed all the rules and regulations. It was bona fide, but in your research, have you seen anything or found anything that would indicate to you that maybe cast a shadow or a light on part of the investigation?
Well, In reviewing the lawsuit, there were several things that the LHSAA seized upon, but the main thing, even though they cited 6 separate rule violations, was the bona fide change of residence requirement. There were several things that they seized upon, one of which was the fact that Coach Robison, Mr. Robison, was taken back by the question of whether he was making a permanent move to St. Charles Parish, and instead indicated to the investigators that, well, they were going to stay there a year and then decide what they were going to do, which does not sound like a permanent move.
Could part of that taken back be because there was a form? I want to bring out the fact that on the bottom, we, James Robison and Collier Robinson, father and mother of the player, are residents of the parish of Terrebonne. They actually state in that form on August 19 that they're residents of Terrebonne Parish, but at the same time, they have an apartment in Hornville. What's your opinion of this form?
Well, the bottom of this form is a consent for treatment. And the purpose of it is if a young man gets injured in the course of a ball game and needs medical treatment, the parents are consenting to that. So it's a relatively important thing. And I would assume that they reviewed it prior to signing it. And they're indicating that they are residents of Terrebonne Parish. So I guess it's a corroboration of what is above, that they are living at 332 Lakewood Drive in Houma, which is obviously in Terrebonne Parish. It probably will provide them some difficulty.
And I definitely would love to hear from Mr. Moyer, who's the legal for the Robinson side. We want to be fair to all sides. And these are all documents that I'm sure, if this moves forward, are going to come into play. As a defense attorney, you're looking at them and you're going, sometimes you look and say, well, this is problematic, or looks problematic, but it's really not problematic, or either side can make a whole lot of a form. In your opinion, is this problematic?
I believe it is. As I said last week in our interview, what was a lot more interesting to me than the allegations in the lawsuit were the documents that were attached to it. The documents usually tell the tale. Anybody can allege anything they want in a lawsuit, but the problem usually is how to prove it. This certainly is evidence to the contrary relative to their having made a bona fide change of residence, particularly given the date that this document is signed.
We know the investigatory process of the LHSAA started taking place, and if we read the documents on there, if I recall, said 8/20 they assigned investigators to this case. So right around the exact same time, give or take 24 hours, which may make a difference. The Robisons were signing a form for their other son to be involved in Terrebonne Parish, and they listed 332, let's bring up the form again, 332 Lakewood Drive. How does this play in to the bona fide move and the 2 residencies, in your opinion?
Well, under LHSAA rules, dual residency is not allowed. Now, when we compare this document with not only what's alleged in the lawsuit, but also the attachments, the dates provide interesting commentary on, whether or not the allegations are consistent. This form to play TPR football is dated August 19th of 2018. In the lawsuit, it's alleged in paragraph 107 and 108 that Vanderbilt Catholic High School, through Jeremy Geldner, committed fraud by taking a picture of the Robison residence at this address and not including a for sale sign or a sold sign on the house. That photograph was apparently considered and also submitted with the concurrence form. The concurrence form is dated August the 14th, which is 4 days before this form is signed. So I believe it's at least at first glance, a difficult case to make for fraud, trying to or showing that the Robisons are potentially maintaining a dual
residence. Let me absorb
residence.
this. You're saying that they accuse the principal of Vanderbilt of fraud because he listed in his concurrence form their address that they were still there on the 14th, and then on the 19th they fill out a form for their son to play in Terrebonne Parish and list the same address 5 days later that they're accusing the principal of fraud on.
That's correct. That's correct. Additionally, when you look at the form itself, that the LHSAA, the Notice of Rule Violation, that investigation started, as you pointed out, on August the 20th, only one day after this form was signed. So the statements made about the residency and all of that, and it's, by the way, it's not clear that the LHSAA even knew about this form, but when this form is signed on the 19th, this is right before the investigators were appointed, right before the statements were taken. So it's a very tight time frame to establish the residence.
So when you're looking at this as a defense attorney, and you've done a lot of defense work, is there any, and I want to be fair to the Robinsons, we want to make sure that there's so many people, once again, kids, that are right in the middle of this. They had their house up for sale. I think the first time around it, somebody signed a contract, but that one didn't go through. They put it up again. Any defense on the fact that, hey, our house was still up for sale, we just listed it because it was a physical address?
I think listing the house is one thing, and there's some provisions in the rules for that. However, I think the difficulty is when you look at this form, there's no indication that a house is for sale. At this point, on August the 19th, they've already indicated that they were living in St. Charles Parish at that point. They've already signed a lease in St. Charles Parish 3 months before, and this is a statement from Mr. Robison that they are living at 332 Lakewood Drive in Houma.
So they have a lease prior to him signing that form. They have a lease in Hornville. So the question would be, why didn't Mr. Robison just put the Hornville address on that form he signed with Terrebonne Parish?
If, in fact, that was their permanent address. Because remember, that lease was submitted, at the very least, with the lawsuit in support of the assertion that their residence is actually in Hornville, in St. Charles Parish, rather than in Terrebonne Parish.
Once again, we don't know what everybody's thinking because 25% of the lawsuit is the Robison and the young man. Other 25% is Vanderbilt Catholic. Other 25% is Coach Jeremy Atwell. Other 25% is Hornville. And once again, I think you answered this pretty well the other night, but I want to reiterate it for the audience. Why would he sue Hornville again?
Well, I think that was to provide insulation probably for the school, or at least some modicum of insulation in the event the court granted their TRO and Hornville allowed him to play. Hornville, if ultimately their order was revoked, may not have to forfeit a game that he would have played in. I think that was probably the intent. Now, whether it worked out that way or not is only speculation.
So the LHSAA, in fairness to them, we know they've made some tough decisions over the years, and not all of them have fallen into, correct phase, so to speak. But they were getting hammered pretty good on this investigation. And before everybody really knew the facts, before they actually sent them out and they had the facts and people were making statements, there was a lot of speculation. Now that you've seen the actual LHSAA findings and the parts where they interviewed everybody involved, let me just real quick maybe ask you in order of the principal, Jeremy Geldner at Vanderbilt. He filled out a concurrence form, item 13, and then the explanation of 13 is what got everybody in orbit, including the Hornville side, because he had to fill out what the actual violations were from their viewpoint. but he cited really the rules and regs for most of it.
Right.
Do you see any difficulty on his part of defending his part in this lawsuit?
Remember, to defend his part of the case, they're going to go through the discovery process. There'll be depositions taken, written questions, interrogatories answered, documents produced, probably much more documents than what we've looked at here. And so that's a little bit speculative, but I will say that I believe to make a case for fraud against him or against the school because of what he may have done would be pretty difficult when 5 days after he submits the concurrence form that alleges potential dual residency, that there is a document signed by Mr. Robison stating that they are living, in fact, in Houma.
If it comes to fruition, and we've heard from multiple sources that Mr. Geldner called the principal at Hornville to give him a heads up on what he was filling out and sort of tell him, maybe get your house in order kind of thing. That sort of takes the malice out of it, doesn't it?
It does, and I don't think there's any malice at all. If you
That's what I'm saying. If he made the call, there is no malice.
I think the call is made both from the standpoint of goodwill, professional common courtesy between principals, but also if you look at
both were coaches.
Correct. And if you look at the investigation, though, it's clear that the Vanderbilt administration, both Mr. Geldner and Coach Atwell, had no malice. They indicated to the LHSAA that they had no desire to see Andrew not be able to play his senior year. That was not their intention. And it's my information that even after the sanction came down, they went on record as saying that they believed it was overly harsh. So I don't think there's any case for any malice at all.
Fred, we appreciate you coming on board. And as always, we invite the other side. We did make a phone call for Andrew's attorney to appear. We called him late last week. I'll try again today to see if we can't get him scheduled on to see if they want to give their side of the story. But once again, we've only heard from 25% of those involved in the lawsuit. We'll try to keep you up to breast with information as we get it. But Fred, thank you once again, and I'm sure we'll see you in short order.
You're welcome, Martin. Glad to be here.
All right, we'll take a short break. We'll be back with more here on Bayou Time. Don't go away.